Thank you very much. So let me provide you with just a little bit of background about this American Heritage opportunity. Immediately after 9/11, a then editor of the Modesto Bee was deeply concerned about what young people thought about what their American heritage actually was and what it meant to be an American. And so it was decided then through a partnership with Modesto City Schools, the Modesto Bee, and the Stanislaus County Office of Education to create this opportunity for once a year high school students, in particular juniors and seniors, to really contemplate what it means to be an American. Every year a prompt has been created that addresses the Constitution in some way, shape, or form. And tonight certainly is no exception. I want to personally say that the partnership between these three entities has been strong throughout the 17 years that we have been doing this scholarship opportunity. I want to say thank you to the new superintendent, Sarah Noguchi of Modesto City Schools, who is here. And with her are Brad Goudeau and Janine Zambo. A big thank you to them as well. Behind me is Mike Dunbar. Mike will be speaking to you as soon as I finish, and Mike is the editorial opinion editor, pardon me, for the Modesto Bee, and he's been very, very involved in this process as well. So let me tell you how this is going to work. First, behind the scenes, an American Heritage Committee has gathered, and every year we do this, and try to find a prompt that is particularly engaging to high school students. Sometimes we take advantage of recent or upcoming events, anniversaries, or special topics of interest, and every single time we create a prompt, it always allows a student to take a stand, for or against. There are no right answers. It's all about the logic and the rationale and the research that you do to support the stand that you take. When you hear the biography of this evening's speaker, you're going to know that we have an incredible guest speaker tonight, and we're proud to say that he is locally grown. Yay. So.
Go Downey.
You're at the wrong high school, actually. So we create an evening like this evening, and students and community members are invited to come in. As I said before, we'll be taping the presentation, so a student who has a conflict this evening or who lives too far away to make the trip in has an opportunity to watch this later on. Know if you are a student in the audience, there will be a PowerPoint presentation that's going to be shared. You do not have to furiously take notes because those PowerPoint slides will be embedded in the videotape that's going to be on the SCOE website in a little bit. So don't feel like you have to scribble and write furiously. Then the students write to the essay, focusing on the prompt. As you probably already know, this year's prompt is focused on the, quote, right to bear arms, end quote. Once we receive the essays, we screen them to make sure that the writers of those essays have followed the directions. And here's a big heads up to students. You're going to hear this more than once. Please follow the directions. If you don't, unfortunately, the essay will be disqualified. We bring together an illustrious group of local educators, newspaper editors, and community folk who volunteer to read and score the essays, and we narrow the field to 20 essays. Each essay submitted is read at least 2 times. The top 20 essays are sent across the street from the Stanislaus County Office of Education to Denise Curtis, who organizes the Stanislaus County Superior Court volunteers, the judges, who will then read and rank the final 20 essays. Their ranking allows us to award scholarships. Typically, we distribute $10,000 each year in the form of 19 different scholarships. The very top essay is awarded a $2,000 scholarship, and there are 9 $1,100 scholarships distributed, along with several other scholarships of different denominations in between. Thus far, we're almost at $160,000 that's been donated to students. So I need to pause right here and tell you that all of the scholarship money that is distributed to students and has been distributed to students is donated from individuals in this community. And I would like to say a thank you to Kathy Hobby. I know the lights are down. Kathy Hobby was at the front desk when you came in because she is a fund development specialist for the County Office of Education. And she goes around and she knocks on doors and she gathers that money. So would you give her, please, a round of applause? I would be very remiss if I didn't also publicly acknowledge and say thank you to Valerie Escobar, who was also at the front desk when you came in from the Stanislaus County Office of Education. She coordinates this program. She will receive the completed essays. She will organize the reading session in October, and she will be sending the invitations to those who are awarded scholarships for our November awards ceremony. Just as a heads up, if you're an adult in the room, maybe a teacher, maybe a community member, especially by virtue of the fact that you're in the room tonight, we'd love to have you help us read those essays. It's really, really fun. We begin at 8:30 in the morning on Tuesday, October 30th at the Stanislaus County Office of Education, and they are really good essays to read. If you're interested, please note that Valerie Escobar's contact information is in your program, and you can reach out to her. We would love to have you, and lunch is on us. Without any further ado, I'd like to introduce a representative from one of our partners, the Modesto Bee, Mike Dunbar, the opinions page editor. Please welcome him.
Well, hello. When we first started this 17 years ago, I thought, Dick LeGrand, he's the opinions page editor. Man, what a curmudgeon. Well, now, 17 years later, I am the curmudgeon. So, and they've asked me to speak a little bit about what readers are looking for, because I help coordinate the reading and the grading of the papers, if you will. And the first thing we look for is that did you follow the instructions? Did you address what you were asked to address? And then after that, you have to fill in, you have to be sure that you get all of the appropriate references and cite the appropriate cases. But as a newspaper writer, one of the things that I look for is something a little more than just something you would do for classwork. I would like to have a little bit, just a tiny bit perhaps, of personality. Make your statement bold. If you're going to state an opinion, and you will be asked to, state it boldly. Don't try to have it both ways. There's an old saying about editorial writers that they all have three hands because they love the phrase, on the other hand. So don't do that. Don't be like an editorial writer. Make your statement and then prove it. Use that. So that's kind of that's my best advice for you. I'd like to introduce all of the other members of the committee, and we'll start with someone who's going to follow me to the podium, and that's William Broderick Vija. Valerie Escobar, we've already mentioned her. Cheryl Goulart, Kathy Hobby, Susan Rich, and Janine Zambo. A little bit more about William. I've known him a while. He was one of our visiting editors. And by the way, when you get into college or out, and if you're still around this area and you'd like to become a visiting editor, I'll make the pitch right now. We'd love to have you. For the adults in the room, you don't have to wait. We meet regularly, and like this Thursday, we'll be doing an editorial board with Josh Harder and Jeff Denham, running for Congress. You may have heard their names. But I've known William since he was involved in that project. Would love to have him back if he ever has the time. He's a longtime member of the American Heritage Scholarship Steering Committee. I think he's been there at least as long as I've been. He is a former teacher, former elected official, doesn't look old enough to be all these things, a current probate attorney here in Modesto. And it's through William that we will extend the invitation to our speaker tonight.
Thank you. Thank you, Mike. As Mike Dunbar mentioned, I'm a current attorney, but I'm also a former teacher. I used to teach at Waterford High School for 7 years. And the American Heritage Scholarship Committee is one of the committees I served on before I took a hiatus and went to law school, that I've also returned to since coming from law school. It is near and dear to my heart, and I thank the city of Modesto City Schools and the County Office of Education for that partnership, and the Modesto Bee. Where did Mike go? Oh, and the Modesto Bee, because it's very farsighted what we do in this community in terms of engaging at a scholastic level with what it means, what our Constitution means, and how that contributes to our society. I'd be remiss if I didn't mention one of the other institutions that was essential in getting the American Heritage Scholarship Committee off the ground, running, and supported through all of these years. One of the founding members of the program is actually in attendance this evening. He is a retired professor who was also a featured presenter for this program, and it's Dr. Curtis Grant. I served on the committee with him for several years before I went off to law school, and it is fitting, actually, that his son, Eric Grant, is the presenter tonight. Dr. Curtis Grant has contributed ideas, energy, talent, treasure to support this, and vision to help support. And as an educator, he has been instrumental in getting this committee up and off the ground and going year after year. And if Dr. Curtis Grant, you don't know this, but I have an award for you here tonight. If you can come on up and be honored. Valerie, are you taking pictures here? Dr. Grant did not know about this award, but it's important to acknowledge him, and it's also fair because today at Rotary, he surprised his two sons with awards at Rotary. So little did he know that he was going to be awarded tonight. But this program would not have been here but for his leadership and vision and continued support. And also for introducing us to tonight's speaker. Of the 9 justices sitting on the Supreme Court, and actually Justice Kennedy just retired, so of the 8 justices sitting on the Supreme Court right now, 4 previously clerked for prior Supreme Court justices. Those are Justice Gorsuch, Kagan, Beyer, and the Chief Justice, John Roberts. In addition to this, 3 other justices in the Supreme Court history have also served as clerks. Those were the late Chief Justice William Rehnquist, retired Justice John Paul Stevens, and the late Justice Byron White. Right now, there is a vacancy, and if the nominated person, that is Brett Kavanaugh, is confirmed by the Senate, he would be the 5th sitting justice who also previously clerked for a prior justice. On California's Supreme Court today, 2 out of the 7 California Supreme Court justices clerked for the United States Supreme Court. It is a very prestigious and trust-filled position for a Supreme Court justice to choose you as a clerk. And it turns out with our speaker today, 2 Supreme Court justices chose him as clerks. The first was the retired Chief Justice Warren Burger, and Eric Grant actually served as a pallbearer at the late Chief Justice Warren Burger's funeral. And then the current sitting Justice Clarence Thomas also chose him as a clerk. He is a Deputy Assistant Attorney General in the United States Department of Justice today. He is from Modesto. He is from Downey High School, was it? Okay. Well, I went to Oakdale and then I taught at Waterford, so I don't know. But Downey, thank you to Downey, thank you to Beyer, thank you to Modesto City Schools. It is quite an honor to have him tonight. He is the eldest son of Dr. Curtis Grant and Mrs. Nancy Grant of Modesto. He graduated from Downey in 1984. He obtained his undergraduate degree in 1986 from Berkeley and his law degree in 1990. During his 28-year career as a lawyer, Mr. Grant has served as a law clerk, as I mentioned, first to the retired Chief Justice Warren Burger and then to Justice Clarence Thomas. He has argued cases in the United States Supreme Court, the California Supreme Court, and numerous other federal and state appellate courts. Following 2 decades in private practice in Sacramento, Mr. Grant last year joined the Environmental and Natural Resources Division in the U.S. Department of Justice in Washington, D.C. This year's prompt is printed on the backside of your program. Did everybody grab a program as they came in? Along with some key dates for the publication of the essays. It is also listed on the SCOE, that's the Stanislaus County Office of Education website. The prompt: the Second Amendment in the Bill of Rights of the United States Constitution states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. How should the right to bear arms be interpreted and enforced in 2018? In a well-crafted, logical essay, take a stance on the issue and provide references to primary and secondary resources in support of your opinion. Bottom line, students, you are asked to take a stand and support your response. Please make note that of the 4 required sources you will cite in your essay, 1 must be a quote from Mr. Grant's presentation. Let's welcome Eric Grant, our speaker for tonight's topic.
Thank you, William, for that kind introduction. It's an honor and a pleasure to be here in my hometown and to be part of a program that my father helped establish and foster. For that, I want to thank, in addition to William Broderick Vija, both Sue Rich and Valerie Escobar at the Stanislaus County Office of Education. It's been great to work with you. Let me add my thanks, too, to the generous individuals and local businesses who have contributed scholarship funding. I'm pleased to see family members and friends in the audience. I won't embarrass you by mentioning your names, but I do appreciate your coming out to support me tonight. Before I dive into the substance of our topic, I have a couple of lawyerly matters to get out of the way. First, you know from my brief biography that I'm a Deputy Assistant Attorney General in the U.S. Department of Justice. I need to make clear that nothing I say here tonight represents the official views of the department or the incumbent administration. And second, nothing I say is intended to support or oppose any candidate or otherwise influence any election. One more preliminary point. If it helps your comprehension, please take notes. But as William said, you needn't take notes for fear of missing the sources to which I refer. The visual presentation that you see, including the hyperlinks to many sources, will be available for download. And we're going to see, we do have a visual presentation. With that out of the way, let's get to what we came to consider, the Second Amendment to the United States Constitution. And there it is. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And let's see if the slides, if I do, there we go, perfect. As I'll discuss in more detail later, your task is to write, as William said, a well-crafted logical essay that addresses how should the right to bear arms be interpreted and enforced in 2018. That's a daunting task regarding a huge topic. Where to begin? Justice Oliver Wendell Holmes Jr. famously wrote that on certain points, a page of history is worth a volume of logic. So let us begin with a page of history, starting with the colonial and revolutionary periods. That is, before we officially became a nation with a constitution and a Bill of Rights. Starting in 1765, an English lawyer and judge named Sir William Blackstone published a 4-volume treatise called The Commentaries on the Laws of England. You'll have to trust me that Blackstone's commentaries were enormously influential in the development of American law, particularly including constitutional law. Oh, there we go. Thank you. Blackstone identified 3 great and primary rights of Englishmen, namely personal security, personal liberty, and private property. To vindicate those primary rights, the subjects of England were entitled to various auxiliary or subordinate rights. The one that interests us tonight is the right of having and using arms for self-preservation and defense. In other words, one of the ways for a citizen of England to ensure his personal security, personal liberty, and private property was to have and use arms. From 1776 onward, when the American colonies became what the Declaration of Independence calls free and independent states, when that happened, they framed constitutions, and these constitutions had what we now call Bills of Rights. Here are some of the provisions that should interest us. They're there for you to read, but I'll read a couple of these. Virginia, in 1776, that a well-regulated militia composed of the body of the people trained to arms is the proper, natural, and safe defense of a free state. North Carolina, also in 1776, the people have a right to bear arms for the defense of the state. Pennsylvania, also in 1776, phrased slightly differently, that the people have a right to bear arms for the defense of themselves and the state. Let's skip ahead to some others. Pennsylvania in 1790, the right of the citizens to bear arms in defense of themselves and the state shall not be questioned. Kentucky, 1792, the right of the citizens to bear arms in defense of themselves and the state shall not be questioned. We can see a few patterns here of all these provisions speak of the defense of the state, and one of them locates that defense in a well-regulated militia, a phrase that appears in the Second Amendment. More than half of them, particularly the latter ones, speak also of the defense of themselves, that is, the defense of the individual citizens who have the right to bear arms. This brings us to the framing of the Constitution and the Bill of Rights. It's an auspicious time to have this lecture because yesterday, September 17th, is Constitution Day. That is the day in 1787 when the Constitution was signed by the Philadelphia Convention and sent to the people of the several states for ratification. And next week, September 25th, is Bill of Rights Day. That is the day in 1789 when the first 10 amendments to the Constitution were passed by the first Congress and sent to the states for ratification. Why did these two events occur in different years? Or why did the new Constitution need amending even before it got fully implemented? One reason was that some of the conventions that ratified the original Constitution, particularly in the influential states of Virginia and New York, coupled their ratifications with demands that the new Congress propose a Bill of Rights. Let's look at the relevant portions of these demands. First, New Hampshire in June of 1788 demanded that Congress shall never disarm any citizen unless such as or have been in actual rebellion. The influential state of Virginia, also in June of 1788, that the people have a right to keep and bear arms, that a well-regulated militia composed of a body of the people trained to arms is the proper, natural, and safe defense of a free state. Sounds a lot like the eventual Second Amendment. Some others, New York, that the people have a right to keep and bear arms, that a well-regulated militia, including the body of the people capable of bearing arms, is the natural, proper, and safe defense of a free state. North Carolina and Rhode Island proposed provisions essentially identical to Virginia. Again, we can see a pattern here. The right to keep and bear arms is coupled with the endorsement of a well-regulated militia. But notice that in these demands, the right does not appear to be subordinate to or dependent on the militia. We come then to the Bill of Rights and the Second Amendment proper. The first Congress of the United States of America convened on March 4th, 1789 in New York City. Although everyone agreed on the necessity and importance of a Bill of Rights, it was not until many months later, on September 25th, as I said, that the proposed amendments actually passed both houses of Congress. As you certainly know from your study of the Constitution, amendments take effect when they are passed by 2/3 of each house of Congress and ratified by a certain percentage of the states. If you're a student and know that percentage, shout it out. Did I hear it? Come on, have the courage of your convictions. 75%, 3/4, yes. Representative James Madison of Virginia, who had played a leading role in the Constitutional Convention of 1787, who would later serve as President Thomas Jefferson's Secretary of State, and who would eventually serve 2 terms as president himself, is generally said to be the father of the Constitution, and is said to have drafted the Bill of Rights. In contrast to separate amendments following the body of the Constitution, what we actually have today, Madison proposed to insert the various amendments into that body. Interestingly, he would have inserted what became the Second Amendment, not among the provisions dealing with the militia, but among the various individual rights in Article 1, Section 9, along with other individual rights like the freedom of speech. In any event, what emerged from the drafting process and were eventually ratified by the states were 10 separate amendments with which we are familiar. Now, given the Second Amendment's reference to the right of the people, emphasis on people, which I will discuss later, it is interesting to view the Second Amendment in context with its compatriots. So first we have the First Amendment. I haven't quoted the entire thing, but in relevant part, Congress shall make no law abridging the right of the people peaceably to assemble and to petition the government for redress of grievances. Then there's the Second Amendment. Then there's the fourth, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And then there's the Ninth Amendment with reference to rights retained by the people. The Second Amendment, along with the other 9 amendments, became part of the Constitution when Virginia became the 11th state, making 3/4 of the original 14, or the then 14 states, to ratify them on December 15th, 1791. Moving forward from 1791, the Second Amendment did not play a significant part in 19th century legal history. That is largely because for much of our history, including with a very small exception, all of that century, the Bill of Rights operated as a restriction only on the federal government. And believe it or not, the federal government played a comparatively small part in American life, particularly in legal matters. The great Chief Justice John Marshall, writing for the U.S. Supreme Court in 1833 in the case of Barron v. Mayor of Baltimore, held that the Bill of Rights, quote, must be understood as restraining the power of the general government, not as applicable to the states, unquote. The general government being what we call now the federal government. The Barron case concerned the Just Compensation Clause of the Fifth Amendment, but the Supreme Court said the very same thing with respect to the Second Amendment in a case called Presser v. Illinois in 1886. There the court reiterated, there it is, quote, the amendment is a limitation only upon the power of Congress and the national government, and not upon that of the states. This is one of the amendments that has no other effect than to restrict the powers of the national government, unquote. In legalese, this means that the Second Amendment was not incorporated against the states, an issue to which I'll return. Before we leave the 19th century, let's look briefly at the analogous rights protected by various state constitutions. Here are the first 7 adopted in the 1800s. So I won't read them all because they're in large part very similar. Let's just pick Indiana, that the people have a right to bear arms for the defense of themselves and the state. We move forward to 1819, 1820, Missouri, that their right to bear arms in defense of themselves and of the state cannot be questioned. Slight differences in wording, but a lot of essential similarity. If we go to 5 constitutional provisions adopted near the end of the century, all of these in 1889, we'll start with Washington. Now let's skip Washington and go to Montana. Montana's kind of interesting. The right of any person to keep or bear arms in defense of his own home, person, and property, or in aid of the civil power when thereto legally summoned, shall not be called into question. But nothing herein contained shall be held to permit the carrying of concealed weapons. That's something new that we haven't seen. And Idaho, I think, is interesting as well. The people have the right to bear arms for their security and defense, but the legislature shall regulate the exercise of this right by law. We may observe 2 things about these various provisions, which are just a sample. First, there's a near uniformity in the right of citizens to bear arms in defense of both themselves and the state. Second, in the latter set of provisions, some of the issues have a modern feel. We looked at Montana, for example, which does not extend the right to keep and bear arms to the carrying of concealed weapons. And Idaho grants its legislature the authority to regulate the exercise of this right by law. That brings us to the 20th century, and in particular to the case that was the Supreme Court's only serious treatment of the Second Amendment for more than 100 years, and until very recently. That's United States versus Miller, decided in 1939. It contains what Professor Eugene Volokh of UCLA Law School, whose web pages are cited in these slides, calls the only extensive modern discussion of the amendment before the 21st century. What Miller really said, and what later cases said Miller really said, are the subjects of great debate, and I don't intend to try to say definitively here. On the slide, I've given you a couple of scholarly articles that I think make interesting contributions to that debate. One of those professors, Nelson Lund, describes the case this way. The National Firearms Act of 1934, part of the New Deal legislation, imposed a substantial transfer tax on short-barreled shotguns, along with onerous registration and record-keeping requirements. Miller arose from a criminal indictment charging 2 men with transporting an unregistered short-barreled shotgun across state lines in violation of the statute. The federal trial court dismissed the indictment, means essentially said it was invalid and could not be pursued, on the grounds that this statute, the National Firearms Act, violated the Second Amendment, but gave absolutely no explanation for this conclusion. The government appealed directly to the U.S. Supreme Court, but the criminal defendants failed to appear and argue and present argument through their court-appointed lawyers, perhaps because they'd been released from custody and had disappeared. But interestingly, neither the court below nor the criminal defendants offered the Supreme Court any argument, in short, in support of the challenged judgment. And so the justices heard arguments only from the government. Now, as a government lawyer right now, I kind of like that idea, but it's peculiar. In these circumstances, it's perhaps no surprise that the court delivered what Professor Lund calls a narrow and even tentative decision. Here's what the court actually said about the Second Amendment. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length, and that's quoting from the statute, at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. And it goes on, and you can see that on the slide. After a discussion of militias in England and the newly independent states, the court concluded with what can only be described as an anticlimax. Most, if not all, of the states have adopted provisions touching the right to keep and bear arms, and we've seen some of those provisions. Differences in the language employed in these have naturally led to somewhat variant conclusions concerning the scope of the right guaranteed, but none of them seem to afford any material support for the challenged ruling of the court below. So the Supreme Court ended its opinion, which was unanimous, as follows. We're unable to accept the conclusion of the court below, and the challenged judgment must be reversed. The cause will be remanded for further proceedings. So, as Professor Lund observes, the court did not hold that short-barreled shotguns are outside the coverage of the Second Amendment, but only that it has seen no evidence that these weapons have certain militia-related characteristics. Consequently, in sending the case back to the trial court for further proceedings, the Supreme Court gave the defendants an opportunity to offer the kind of evidence called for in the court's holding. Of course, they never offered that evidence because they had absconded. So the Miller opinion referred to, quote, somewhat variant conclusions concerning the scope of the right guaranteed. And that gives us the opportunity to switch from history to theory. What are these variant conclusions? In fact, there are two basic conclusions, which are sometimes called the individual right interpretation versus the collective right interpretation. And sometimes they're called the standard model versus the states' rights model. Professor Glenn Reynolds, whom some of you may know as the internet's Instapundit, wrote a good summary of these competing interpretations as of 1995 in an article called A Critical Guide to the Second Amendment. That's one of the articles cited there. And if this works, you should be able to click on those and you'll get the article. Professor Reynolds summarizes the individual right model as follows. The purpose of the right to bear arms is twofold: to allow individuals to protect themselves and their families, and to ensure a body of armed citizenry from which a militia could be drawn, whether that militia's role was to protect the nation or to protect the people from a tyrannical government. Though recall that we saw many times defense of themselves and the state, two purposes. This conception harkens back to Blackstone's understanding of the right as the right of having and using arms for self-preservation and defense in order to vindicate personal security, personal liberty, and private property. In this so-called standard model, the Second Amendment's first clause, a well-regulated militia being necessary to the security of a free state, is what Professor Volokh calls the justification clause, as opposed to the second or operative clause. In this understanding, the operation of the amendment may be both broader and narrower than its justification. Narrower in that the government is entitled to act in ways that are at odds with the amendment's justification, so long as it doesn't deprive the people of the right to keep and bear arms. Congress may even take steps that undercut the value of a well-regulated militia to the security of a free state, for instance, by creating a standing army, as it is in fact done with the United States Army. The operation of the Second Amendment might at the same time be broader than its stated justification. The first clause refers to the militia only, while the second protects the right of the people. But the militia, in the nearly universal understanding from the 18th century to today, has always generally included pretty much all able-bodied men, and only those from age 18 to 45, rather than all people. By contrast, it's undisputed that the other rights of the people, those protected by the First, Fourth, and Ninth Amendments, extend to all persons within the United States. Let's look now at the competing collective rights interpretation. In this interpretation, as summarized by Professor Reynolds, the Second Amendment protects not a right of individuals, but only the right of states. Thus, the right protected is simply the right of states to have a well-regulated militia. In this model, the purpose of the Second Amendment is to guarantee the existence of state military forces that can serve as a counterweight to to a federal standing army. Thus, the scope of any rights enjoyed by the states under the Second Amendment would be determined by the goal of preserving an independent military force not under direct federal control. Now, he echoes a seminal article by practicing lawyer Don Cates, and I think that's cited there. Professor Reynolds charges that the states' rights theory did not appear at all until the 20th century, when it seemed necessary to be created in order to uphold gun control laws, primarily intended to disarm black people and immigrants against Second Amendment challenge. Before we tackle the Supreme Court's recent treatment of these competing interpretations and other key Second Amendment issues, let's pause to look at the state of the larger culture. In addition to a spate of new Second Amendment-related scholarship beginning in the 1980s, the 1970s saw the public increasingly concerned with crime, and particularly with guns in the hands of criminals only. People my generation and older will remember Clint Eastwood in Dirty Harry in 1971 and Charles Bronson in Death Wish in 1974, which seemed to come to real life in the 1984 New York City subway shooting involving an individual named Bernard Goetz, G-O-E-T-Z. The 1990s saw additional scholarship, and in 2000, the U.S. Court of Appeals for the Fifth Circuit issued a lengthy opinion holding that the Second Amendment, quote, protects the right of individuals, including those not then actually a member of any militia or engaged in active military service or training, to privately possess and bear their own firearms, such as the pistol involved here, that are suitable as personal individual weapons and are not of the general kind or type excluded by Miller, referring to the case of United States v. Miller. This is obviously the individual right interpretation. Now, in the case of United States v. Emerson, the Fifth Circuit ultimately rejected the defendant's claim that the Second Amendment required dismissal of the charge against him. But in so doing, it became the first federal appellate court in modern times to affirm the individual right interpretation and to reject explicitly the collective right interpretation. While all this was happening in academia, in culture, and in the courts, state legislatures were active as well. I'd like to focus on what are often called right to carry laws, that is, state statutes that govern whether and under what condition individuals may lawfully possess weapons, typically handguns, for self-defense. The following 32 slides show the evolution of that right over the period from 1986 to 2017. And we'll look briefly at the color coding here. As indicated in the lower left corner of slide 18, red means no issue, that is, you can't get a carry permit. Yellow means may issue, such that whether you get a carry permit is dependent upon the goodwill of a government official, like a local police chief. Blue means shall issue, such that most individuals are entitled to receive a carry permit once they've passed a background check and perhaps completed a gun safety course. Green means unrestricted, no permit necessary. So for 1986, note the predominance of red and yellow. Either you don't get a permit at all, or you only get a permit at the sufferance of a government official. I'm going to page through the next 3 decades. As you watch now, you won't be able necessarily to distinguish individual changes, but you should see the march of colors from red and yellow, as we see here, to blue and green. Here goes. Let's see if this works. There you go. You can watch the changes. You can see the number at the top for the year. And now we're almost all blue, and we're starting to get some green. Here in 2017. So I'm going to go back now, because I want to do that one more time. So again, we've started with either no issue or may issue. And we have, it looks like Vermont is the one state where Even though it's got the liberal Ben and Jerry's, you can have a gun without any restrictions. So let's do this again. Here we go. The red is disappearing, almost gone, not quite. There's Illinois. And lots of green. California and New York, right, are holding out with yellow. And places like Massachusetts and New Jersey as well. Now, what I find interesting is more than 2/3 of this transformation took place before 2008, when the Supreme Court decided the case of District of Columbia v. Heller. Thus, even before Heller, which is, as we'll discuss, kind of the first modern decision about the Second Amendment from the Supreme Court, most of the country, much of the country, at least by geography, is already enforcing the Second Amendment as a practical matter. Now, one notable exception was the District of Columbia. As the late Justice Antonin Scalia described in his opinion for the majority, the district, quote, generally prohibits the possession of handguns. It is a crime to carry an unregistered firearm, and registration of firearms is prohibited. Wholly apart from that prohibition, no person may carry a handgun without a license, but the chief of police may issue licenses for only 1-year periods. And District of Columbia law also requires residents to keep their lawfully owned firearms, such as registered long guns, unloaded and disassembled or bound by a trigger lock or similar device, not really ready to use. There's Justice Scalia's description of the District of Columbia law. Now, Plaintiff Dick Heller was a D.C. Special Police officer authorized to carry a handgun while he worked in the Thurgood Marshall Judiciary Building. He applied for a registration certificate for a handgun that he wished to keep at home, but the district refused. So, like a good American, he filed a lawsuit in federal court for the District of Columbia, seeking on Second Amendment grounds to enjoin the city from enforcing the bar on the registration of handguns, to enjoin the licensing requirement insofar as it prohibits the carrying of a firearm in the home without a license, and the trigger lock requirement insofar as it prohibits the use of functional firearms within the home. Dividing 5-4 along what is usually described as the conservative liberal fault line, the Supreme Court ruled in favor of Mr. Heller. The majority opinion by Justice Scalia had 3 principal holdings. First, over the course of 50 pages, which I'll tell you is very long for a Supreme Court opinion, the court held, and here I'm actually cribbing from the court's syllabus. If you're a lawyer, don't do this, but it's good for a lecture. The Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes such as self-defense within the home, unquote. This, as you now know, is the individual rights interpretation of the amendment. For the 4 dissenting justices, now retired Justice John Paul Stephen wrote 45 pages attempting to refute that conclusion. Justice Stevens would have held, quote, there we're going to quote the dissent, the Second Amendment was adopted to protect the right of the people of each of the several states to maintain a well-regulated militia. It was a response to concerns raised during the ratification of the Constitution that the power of Congress to disarm state militias and create a national standing army posed an intolerable threat to the sovereignty of the several states. I'll skip ahead. Specifically, there is no indication that the framers of the amendment intended to enshrine the common law right of self-defense in the Constitution. So let's go to the second holding. In a comparatively brief 2 pages, the court held, like most rights, the Second Amendment right is not unlimited. It's not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment or state analogs. And so the court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons, and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools, that seems relevant here, and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. There was no dissent from the court's holding that this right secured by the Second Amendment is, quote, not unlimited, unquote. So we have a third holding, quite long. We won't read the whole thing. But essentially what the court held is that given these principles, given the individual right interpretation of the Second Amendment adopted by the majority, the handgun ban and the trigger lock requirement as applied to self-defense violate the Second Amendment. And the district's total ban on handgun possession in the home amounts to a prohibition on an entire class of arms that Americans overwhelmingly chose for the lawful purpose of self-defense. So skipping ahead to the bottom line, assuming he's not disqualified from exercising his Second Amendment rights, the district must permit Heller to register his handgun and must issue him a license to carry it in the home. In a sense, the court adopted a must issue or shall issue regime instead of a may issue regime, at least for certain kinds of possession of guns. In a separate opinion for the same four dissenting justices, Justice Stephen Beyer took issue with the court's ruling in favor of Mr. Heller, even on the assumption that the Second Amendment protects an individual right to self-defense. The second independent reason why the majority is wrong is that the protection the amendment provides is not absolute. And this is something to keep in mind, a common argument. The district's law is consistent with the Second Amendment, even if that amendment is interpreted as protecting a wholly separate interest in individual self-defense. That is so because the district's regulation, which focuses upon the presence of handguns in high-crime urban areas, represents a permissible legislative response to a serious, indeed life-threatening problem. Now, slides 55 and 56 detail some of the continuing litigation of the Heller case, including an opinion by Judge Brett Kavanaugh about semi-automatic rifles, and we probably wouldn't be thinking about that unless, if it weren't for the fact that Judge Kavanaugh has been nominated to sit on the Supreme Court. But I will skip that discussion. So that brings us to another issue, variously called Incorporation, or more longer phrase, whether the Bill of Rights, and particularly the Second Amendment, apply against the states. Heller was obviously a case involving the District of Columbia, which is under the Constitution governed at least indirectly by Congress, so it's not a state. As we've previously noted, the Supreme Court held in the 19th century that the amendment, like the rest of the Bill of Rights, does not apply to state and local governments. In the wake of the Heller decision, plaintiffs sought to change that to convince the court to overrule decisions like Presser v. Illinois. And the Supreme Court considered that issue in 2010, just 2 years after Heller in the case of McDonald v. City of Chicago, which challenged local ordinances that effectively banned handgun possession by almost all private citizens. Oh, let me go back here. So McDonald involved two clauses of Section 1 of the 14th Amendment. One, the so-called Privileges or Immunities Clause provides, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Two, and immediately following, the Due Process Clause provides, nor shall any state deprive any person of life, liberty, or property without due process of law. In what are called the slaughterhouse cases, interesting name for a court case, the Supreme Court in 1873 effectively read the first clause out of the Constitution, concluding that the privileges or immunities of the citizens of the United States did not include the rights secured by the Bill of Rights, such that the states were still not required by the Constitution to respect those rights. But the result was different under the Due Process Clause. Beginning in 1897 and proceeding for the next 75 years, the Supreme Court has incorporated most of the Bill of Rights against the state. Thus, if the city of Modesto takes your private property for public use to build a park or a police station, for example, it must pay you just compensation as required by the final clause of the Fifth Amendment. If the state of California seeks to punish you, it may not inflict cruel and unusual punishments, contrary to the final clause of the Eighth Amendment. And neither the city nor the state may restrict your First Amendment rights to religion, speech, press, assembly, and petition. By the time the McDonald case came to the Supreme Court in 2010, virtually all of the many individual provisions of the Bill of Rights had been incorporated. In addition to just the Second Amendment, only the grand jury clause of the Fifth Amendment and the Seventh Amendment, which governs jury trials in civil cases, and the Eighth Amendment's ban on excessive fines had not been incorporated. Even the Third Amendment had been applied to restrict states. Who can tell me what the Third Amendment prohibits? Quartering of soldiers in peacetime, exactly. So even that had been applied, not just to the national government, but to the states. Fortunately, it doesn't come up a lot. So let's get to McDonald. The question was whether the Second Amendment would join most of the Bill of Rights or be relegated to second-class status. The court again split on the same 5-4 liberal-conservative divide, with the conservative majority choosing the former. 4 of the 5 justices applied the traditional test for incorporation under the Due Process Clause, asking whether the right to keep and bear arms is fundamental to our scheme of ordered liberty, or whether this right is deeply rooted in this nation's history and tradition. The 4 justices concluded that our decision in Heller points unmistakably to the answer, and that answer is yes. Interestingly, Justice Clarence Thomas did not join that conclusion. Instead, he concluded that the right to keep and bear arms is a privilege of American citizenship that applies to the states through the 14th Amendment's Privileges or Immunities Clause. And so he spent much of his 53-page concurring opinion explaining why the slaughterhouse cases were wrongly decided. An interesting part of the McDonald opinion was a debate between Justice Scalia and Justice Stevens about substantive due process. Given the time and given that it's somewhat far afield, I'm going to skip it. But I would say, if you're interested in constitutional theory, those are 2 very interesting opinions to peruse. If you're interested in critiquing what Justice Beyer in dissent calls the Heller decision's flawed historical account of the right to bear arms, his opinion is a good place to start, especially pages 914 and 915. If you're interested in all kinds of data, including empirical data that supports Justice Breyer's attack on the court's analyses, see the appendix to his opinion, beginning at page 941. So we have one more issue to consider, one that's close to home. Recall that the Montana Constitution of 1889 guaranteed the right of any person to keep or bear arms in the defense of his own home, person, and property, but that right did not permit the carrying of concealed weapons. Under California law, as described by the U.S. Court of Appeals for the Ninth Circuit in the case of Peruta v. County of San Diego, a member of the general public may not carry a concealed weapon in public unless he or she has been issued a license. Recall, California was a yellow state, a may issue state. An applicant for a license must satisfy a number of conditions. Among other things, the applicant must show good cause to carry a concealed firearm. And California law authorizes county sheriffs to establish and publish policies defining good cause. And so the county sheriffs of San Diego and Yolo published policies defining good cause as requiring a particularized reason why an applicant needs a concealed firearm for self-defense. So you you need good cause, and the sheriffs are going to require you to give a reason other than I'd like to carry it for self-defense. So the plaintiffs in the Peruta case, who lived in those two counties, alleged that they wished to carry concealed firearms in public for self-defense, but admitted that they didn't satisfy the good cause requirements, and so they contended that the operation of those laws altogether violated the Second Amendment. Splitting 8-3, the 11 judges of the Ninth Circuit rejected the plaintiff's contention, and the opinion, though, was careful to distinguish between concealed carry and open carry. So that's a long explanation. I won't read it, but basically what the court says is open carry is an interesting question under Heller and McDonald, but we're not going to worry about that. These plaintiffs have focused on concealed carry, and we're confident that even under the Supreme Court's decisions, concealed carry is not required by the Second Amendment. That brings us to our final case, decided less than 2 months ago. A 3-judge panel of the same Ninth Circuit was called upon in the case of Young v. Hawaii to decide whether the Second Amendment encompasses the right of a responsible, law-abiding citizen to carry a firearm openly for self-defense outside of the home. So Peruta had addressed just concealed carry, and the court was able to say open carry is a tough issue, but we don't have to resolve it. But it came square to the front in the case of Young v. Hawaii. Recall that, or you may recall, and I'm going to tell you, that Hawaii also is a yellow or may issue case, may issue state. And so you could only get a permit to publicly carry a weapon for self-defense if the local police chief thought it was a good idea. So what did the court say in Young? It was a 2-judge majority. Again, there's a lot there. I won't read it, but basically what the court said is, look, in Heller, the Supreme Court said that to bear, remember it's the right to keep and bear arms, to bear means to wear or to carry upon the person in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in the case of conflict with another person. So to bear an object means to carry it, and when used with arms, the term has a meaning that refers to carrying for a particular purpose, confrontation. So if you take that logic, and the court explained a lot more if you read the case, that says that the right to openly carry a weapon for self-defense is within the Second Amendment. Now, the court did end its opinion with a nod to the problem of gun violence. We see nothing in our opinion that would prevent the state from regulating the right to bear arms, for the Second Amendment leaves the state a variety of tools for combating the problem of gun violence. Last Friday, the state of Hawaii and the county of Hawaii filed what's called a petition for rehearing en banc that would cause that case to be reheard by a panel of 11 judges like the Peruta case. So it's not over, and even when it's over in the Ninth Circuit, of course, it could go to the U.S. Supreme Court. So that's all for substance. Let's talk about process. We're back to the prompt. Your task is to write an essay. How should the right to bear arms be interpreted and enforced in 2018? They want a well-crafted, logical essay in which you take a stance on the issue and provide references to primary and secondary sources. So in situations like this one, primary sources are judicial opinions, the cases like Heller, McDonald, and Young, plus the materials like the state constitutional provisions and other historical documents that I've cited. The secondary sources are those law review articles that I've also cited, and you can get via hyperlink. You should probably have a mixture of both, but I would recommend focusing on the primary sources. How to write your essay. First, follow the directions provided by the American Heritage Scholarship Program website. You've already been told that, including the downloadable 2018 American Heritage application packet. You can literally click on that, the packet will come up. So second, follow the directions. And third, did I mention, follow the directions. Writing tips. The webpage helpfully has a link to a video called Writing Tips. The people who run the program thought it was worthwhile, so you should watch it. The same people have posted the 2017 winning essay by Hannah Young of Gregory High School. Ms. Young must have done something right, so you should read her essay. And I recommend that you read or at least skim a 12-page paper by Professor Volokh called How to Write Good Legal Stuff. So here's my personal advice distilled from writing for a living for nearly 3 decades. I've given you more than enough material for research. Actually, your problem is you have way too much, not too little. So consequently, a good part of your task is going to be to think and to organize before you start to write. For me personally, that means taking the time to draft an outline, including a thesis. And a thesis is simply your main point boiled down to 1 or 2 sentences. It takes time to craft a thesis and an outline, but it is time well invested. Once you do begin to write, you need to edit, and edit. No one does his or her best work on the first draft, and so a second draft is always necessary. And a third, if not more, is usually necessary. Finally, what can you address in your essay? The potential subjects that fit within the question, how should the right to bear arms be interpreted and enforced in 2018, is almost infinite. Based on what I've said tonight, I can think of 5, and I'm sure you can think of more. The correct interpretation or model of the Second Amendment, individual or collective. Should the Second Amendment apply against the states and local governments? What does it mean to bear arms? Issues of open carry, concealed carry. What weapons are protected? Semi-automatics, assault weapons, machine guns. Guns and crime, meaning gun violence and defense against gun violence. So thank you for your attention and patience. I'm happy to take questions.
Good evening. Thank you. We've now come to the part of the program where we are going to entertain some questions from students in the audience as far as clarification in the argument. And then we will once again go over some of the guidelines for your essay and where to be able to get that information. And I think I'm going to take this out because I have a feeling that I'm going to need to take a look at the audience. Thank you. That is perfect. So is there any students out there that have some questions that they would like clarified or anything within the argument that can support you in moving forward in your work? Let's go with you.
So just to be clear in our essay, we don't have to state our other points. It's just if we're against it or for it, just our own point.
I guess I'd say you're going to need to be a little more specific. Probably pro-Second Amendment and anti-Second Amendment is a little too broad. Pick a topic and state your thesis, what you think should be the law, how should it be interpreted, and your best reasons for it, citing the primary and secondary sources.
How about the man in the back?
So in your discussion of the justification clause of the Second Amendment, just clarification, in discussion of the collective rights interpretation, so is the justification clause kind of the body of that interpretation?
It is. That's what those who support the collective right interpretation, that's their focus, that first clause. And they would say, in a sense, it's not just a justification clause, it's really an explanatory clause, and it's part of the operative aspect of the amendment.
Other questions? Anything to help clarify, to help better understand, so when you walk out this door, you're fully prepared?
Can we be confident
diametrically opposed. So that always happens. We understand that those are controversial issues. The question is, are you analyzing deeply and engaging with the sources and justifying your answer?
Good question.
And I'd say whatever position you take, you'll probably have at least 4 Supreme Court justices on your side.
Alrighty. What else?
Former history teacher. And it wasn't interesting that before the Civil Rights was written, many people were figuring to what is now the Second Amendment as an inalienable right. I didn't hear that mentioned at all. Because when I was studying the class, I came across that.
That's true.
Even need a Second Amendment.
Right. You hear the term inalienable rights or natural rights, and that's a whole area I could have gone into and didn't. But yes, the 200 years ago, our forebears had a different conception of rights that they existed even before and apart from being written down, and that's certainly an interesting thing to investigate.
Alrighty, thank you. So join me in thanking Mr. Grant in coming tonight. Thank you. Thank you. We recognize you don't have a lot of leisure time and you can choose, you don't have much to choose from, so we appreciate that you've come back to Modesto for twofold. One, visiting your family, which clearly is important, but also showing the community of Modesto City Schools that students that come from our schools give back to the community, not only in what you're doing this evening, but also in society at large. So thank you for your time. Very much appreciate it. I'd also like to thank the students for being here. You could have been home in front of the TV tonight, engaged with your friends, playing the games, doing your phones, doing everything that you do in the evenings, and yet you've chose to come here tonight to listen to some scholarly speech and some good arguments. So thank you for your time and thank you for your commitment to your education, because the more you put into your education, the more you're giving to yourself, and ultimately you're going to be able to give back to our community and our society. So thank you. And lastly, to parents and teachers and all the adults in the room, thank you for supporting the schools. Thank you for supporting your students. We all wouldn't be here if it wasn't for you, so thank you for your commitment in that. So I think that you did hear a theme today, starting from the very first speaker into the next speaker and into the next, and that is directions and really attention to detail. So I'm going to spend the next 3 or 4 minutes talking about some specifics for you. In the past several years, many essays have been disqualified, and I'm sure you picked up on that because we've talked about the guidelines multiple times tonight. So I'm going to go through this, and again, it's going to be also up here on the screen. So there's a couple things that have disqualified essays. First, you need to make sure that you follow the directions, which you've heard. Don't get into this point where you've written a really good essay and you really think it's your best work, and your mom and your dad think it's your best work, but you forgot one thing, but that's okay because it's really good work and you move it forward anyway. Go back to those directions and make sure you follow it all, okay? Don't go with your gut on that one. First, you need to make sure you quote and cite all sources in your essay and be sure to underline these. One of your sources must be a quote or a comment from tonight's speakers, Mr. Grant. In addition to your comment from the speaker, make sure that you have three additional Supreme Court decisions and or scholarly sources. Raise your hand if you think Wikipedia would work for one of these. That's good. You guys are on the right track. Wikipedia will not work for one of these. Be very sure to check all of the guidelines in the packet that's outlined on the SCOE website, and this will be multiple times that you're going to be able to check this, not only in the video that you are going to be able to download, but also outlined in resources. Essays are due October 17th at 5 o'clock, not 7 o'clock or 8 o'clock, but at 5 o'clock, so make sure that you pay attention to detail on that. Those are just the ones that I've shared with you that have disqualified folks. So make sure that you really follow those. At the website listed in your program, you will find the following. 1, a recorded video of this lecture. So if you missed something, or for a couple of students I know that had to leave today, they're going to be able to catch up where they left off, or if you need to re-listen to things, it will be there, in addition to the PowerPoint presentation. The 2018 application packet will be found on the page at SCOE on their website under Related Links. So go to the Related Links tab. Please note that the scholarship essay cover sheet form must be completed online. Don't print it off, complete it online, okay? After completing your contact information, you will, your completed form will be emailed to you in a PDF. You need to print that out. You need to sign it. You need to have your parents sign it. And then you put that on top of your essay. Really old school, right? And then you have to, you move that forward and mail that in. Resources available that will help you with writing this essay include the essay rubric and a web tutorial on writing, which has been produced by the Modesto Bee. And also there were some key points listed also in this presentation. Scholarship winners have attended many well-prestigious colleges and universities, and I'm going to list a few of them. USC, Brigham Young, Cal Poly San Luis Obispo, CSU Chico and Monterey Bay, Stanford University, Northwest University, St. Mary's College of California. UC system is really represented here. So we've got Berkeley, we have Davis, we have LA, we have Riverside, we have San Diego, and Arizona State University. I want to thank you all for coming, and this concludes our presentation. Again, thank you for coming, thank you for participating, and make sure you drive safe. Thank you.